Welcome to This Explainer. We're going to be your legal guide today, demystifying the Ontario power of attorney. Look, we're talking about locking down your family's future before a crisis actually hits. An accident or some sudden illness, it can literally happen out of nowhere. And by the time you realize you need these documents, well, it's usually way too late to make them. So let's just break down exactly what you need to know.
I want you to really think about this. Who makes your decisions today if you suddenly can't? Imagine a major medical or financial crisis strikes right now. Without a solid plan in place, your family can't just swoop in and take over your bank accounts or, make critical healthcare choices for you. It doesn't work like that. Instead, they get dragged into this agonizingly slow, highly stressful, and frankly super expensive legal maze. For your money, they might have to deal with the Office of the Public Guardian and Trustee, or beg a court to become your statutory guardian. And for health stuff, doctors are stuck relying on a rigid government list of substitute decision makers. It is a massive, massive burden to dump on your loved ones during an already terrifying time.
Okay, let's get into what this tool actually is. A power of attorney, or POA, is a living, written legal document. It's the key that grants a trusted person the authority to act on your behalf. Now, hold on. A super common mix-up here is the word attorney. In this context, attorney absolutely does not mean a lawyer. It's just the legal term for your trusted agent, your spouse, your adult kid, or a really close friend. This person essentially becomes your fiduciary. That means they legally have to act honestly, in good faith, and strictly in your best interest. No funny business. And crucially, this whole setup is only for when you're alive, but just unable to manage your own affairs.
So Ontario law actually splits this up into two completely separate documents that do very different jobs. First up, you've got the continuing power of attorney for property. This handles your money, banking, bills, investments, your house, all that stuff. The word continuing is kind of the secret sauce here. It means the document keeps working even if you become mentally incapable. And fun fact, you can set it up to kick in immediately when you sign it or only if you lose capacity. On the flip side, we have the power of attorney for personal care. This one is all about your health, medical treatments, and housing. And this one only triggers when you genuinely can't decide for yourself. Your personal care attorney can't overrule you while you still have your wits about you. Honestly, these two work best as a pair. Because think about it, if you can't manage your health, you're probably not managing your wealth either, right?
Now notice the hard line drawn right at the exact moment of death. I see so many people confuse a power of attorney with a will, but guys, they literally never overlap. Your power of attorney is exclusively for the living. The absolute second you pass away, boom, your attorney's job is over. Done. At that exact moment, your estate trustee, who you might know as an executor, takes over, and they get their power directly from your will. Even if you name the exact same person to be your attorney and your estate trustee, they're basically wearing two completely different legal hats based on two completely different documents. You absolutely need both to be fully covered.
Okay, so how do we actually build this valid legal arrangement? Let's walk through the step-by-step process so you can bypass those clunky government defaults and stay in the driver's seat. Step 1. Choose your attorney incredibly carefully. Trust is everything here. Step 2. Decide the scope. Do you want to add specific conditions, like maybe requiring a doctor's note before the property document activates? Step 3 is completing the actual legal document using the proper wording under Ontario's Substitute Decisions Act. And finally, Step 4, signing it all in front of two witnesses.
And let me tell you, Step 4 is where the whole thing can just completely fall apart. Improper witnessing is hands down the #1 reason these documents get legally tossed out in Ontario. The rules here are incredibly strict. Your witnesses absolutely cannot be the person you're appointing as your attorney. They can't be your attorney's spouse, they can't be your spouse or partner, they can't be your kid, and they definitely can't be anyone under 18. You have to use two completely neutral adults who physically watch you sign the paper. Oh, and a quick mythbuster for you, notarization, actually not required by law in Ontario for a POA. But getting those two neutral witnesses right, that is absolutely non-negotiable.
To really show you why those rules matter so much, let's look at a cautionary tale. There was this Mississauga homeowner in her 70s. She did what a lot of folks do. She downloaded a free online kit to draft her POA. Pretty straightforward, right? But when it came time to sign, she made a fatal error. She had her son, who was actually the named attorney in the document, act as one of the witnesses. Fast forward a few years, dementia tragically sets in, and she actually needs the document. Well, her bank takes one look at it and immediately rejects it because of that witnessing defect. This plunged her kids into a massive, insanely costly legal dispute, and they wound up having to go through the public guardian and trustee anyway. A simple 10-minute check at the signing table would have literally saved that family months of agonizing court conflict.
Another frequent and honestly devastating error is just waiting too long. You've got to execute these documents while you still have the clear mental capacity to do so. Capacity is that legal threshold that decides if you can even make a power of attorney in the first place. When you sit down to sign a property document, you have to clearly understand what you actually own, your financial obligations to your dependents, the massive amount of authority you are handing over to this person, and the harsh reality that they could, in theory, misuse it. If there is even a shadow of a doubt about your capacity when you sign, that document becomes incredibly easy for unhappy family members to contest later on. If you're ever unsure, getting a formal capacity assessment before signing is just a brilliant protective move.
Now, Ontario does offer a free government kit, and hey, it is perfectly legally valid if you follow the instructions to the letter. But when should you actually bite the bullet and hire a lawyer? Well, you should definitely seek professional counsel if you hit any of these red flags. If you own a business or rental properties, your finances are just too complex for a basic one-size-fits-all template. If you've got a blended family, or there's some, let's call it strain among your relatives, you need bulletproof drafting to shut down any disputes. If you want custom conditions like a delayed activation, the wording has to be extremely precise. And frankly, if you're doing this alongside your will, a lawyer just ensures your whole estate plan works together perfectly. Trust me, the financial cost of fixing a botched document in court always dwarfs whatever the initial legal fee was.
So if you do decide to go the professional route, you're probably wondering about the price tag. Typically, a lawyer-drafted power of attorney in Ontario runs somewhere between $200 and $600 per document. Obviously, this can shift a bit depending on your city or how complicated your estate is. Plus, lawyers often cut you a deal, a bundled rate if you do your will and both powers of attorney at the same time. But look at it this way. For that $200 to $600, you are buying absolute certainty. You're ensuring your specific conditions are legally airtight, the strict witness rules were followed flawlessly, and your family is fully protected from the looming threat of an expensive, dragged-out court battle when the unthinkable happens.
If your situation does call for professional help, you might be thinking, okay, great, but where do I even find a decent lawyer for this? Well, Olanur.com is an incredible resource for this exact problem. It's a completely free platform built to take away the headache of cold calling random law firms. You just go to the site, complete Step 1 by briefly describing what you need for your estate planning. Step 2, their AI-powered system does its magic and matches you in minutes with vetted, licensed Ontario estate lawyers who actually specialize in exactly your issue. Then Step 3, you connect with them directly. There's no weird pressure tactics, absolutely no unexpected cold calls, and zero obligation to hire anyone. It's literally just a smart, efficient way to find the right legal pro for your family in a few minutes.
All right, as we wrap up the technical stuff, I do need to quickly hit you with an important disclaimer. Olanur is a technology platform and an online legal marketplace. They are not a law firm themselves, and they aren't a lawyer referral service. Also, this explainer is here to give you general informational guidance based on Ontario rules as of 2026. It does not constitute formal legal advice. The law can be incredibly specific to your personal life, so please always do your own due diligence and consult a qualified licensed lawyer for advice that's actually tailored to your unique situation.
So, here is the absolute crucial point I want to leave you with today. A power of attorney is a relatively small, inexpensive document, but it solves a truly massive, life-altering problem. As we've seen, it keeps you in control, it prevents those agonizing family court battles, and it guarantees your exact wishes are followed. So I'm going to leave you with this final thought. Have you legally protected your family from the unexpected? Or are you leaving your life, your health, and your hard-earned assets totally up to the courts and government defaults? Are you going to take action right now while you're healthy and fully capable to lock in your family's ultimate peace of mind? It is entirely your decision to make, but you really have to make it today.